Video, please, ma'am.
Video.
Thank you, madam.
Thank you. Actually, previously, what happened, we had the state commission where there were 5 members, but all were vacant. Now we have appointed all the 5 members of the state commission, and we are sure that the consumer cases will be taken up. For consumer activities also, we have a sanctioned fund. And actually, because the consumers are not very much aware of
Ma'am, you are not audible. I think there is some connectivity issues. Madam Lina Das, can you hear me?
I think she got disconnected, I believe.
Yes, there is some connectivity issue, I guess. We are trying to connect her. We are trying to connect Madam Lina Das, and till that time, I would like to request Ishanta Sabhapandit sir to kindly interact for a few minutes, please.
No, I think we can proceed with the program as per schedule, and
Right.
when she
Right.
joins, so she can present her deliverables. Yeah?
Surely, surely. So we would like to have our next esteemed speaker of today's webinar, Ms. Bhanita Patwari. So I would like to request Ms. Bhanita Patwari, the advocate and the independent counsel of Delhi High Court and Supreme Court of India. So would like to request Bhanita Patwari to kindly address, please. Thank you.
Thank you so much. I'm really happy to be a part of this webinar because this is really a very close topic, important for everybody from a shop owner to the street vendors. So now, as in practice, the main difficulty we as a lawyer face, we face a lot of difficulties. And with a new enactment, with a new amendment, some provisions have come up, some provisions which were really necessary that has come up. So I am going into the PPT because I have prepared a small PPT for the differences, what are the new provisions we are having right now in a Consumer Protection Act. So firstly, I would like to share one case that is my personal case, because I have filed against Apollo Hospital for some wrong treatment done to my mother. So what I have faced the difficulty in that case, number one, that I had to limit my claim, because that time the claim was very limited to up to 20 lakhs to the District Consumer Forum and to the State Commission, because we always think that we should go from the bottom line. So because I wanted to file it in the District Consumer Forum, I had to limit my claim. And I filed it in 2014. And since then, it is pending. After 1 year, like from 2015, it is pending for the arguments itself. So it is not happening. So these are the difficulties which we face as a lawyer, because it is completely a delayed procedure. Sometimes the presiding officer is not there. Sometimes the other lawyer is not there. Sometimes there is no member in the court for a forum. So now I think with the new enactment, these all things will be improved to some extent, so that the consumers will get the relief from. So Tarali, if I can share my screen.
Sure.
Yeah, surely. You can select the option share screen.
Yes. I got it.
Yes, it is visible.
Just give me. Okay, with the new enactment, because we know, many of us know the word caveat emptor. That means the buyer must be aware of the things which they are buying or which the service they are taking. So now it has turned into the seller, the service provider, beware as well. Because initially the burden was always on the consumer to be aware of the things that, okay, you are buying a thing. If you are buying a product, if you are taking a service. Am I audible, Tarali?
Yes, you are audible.
Okay.
Yes.
If we are a consumer, it is, but the burden was only on us to know the product properly. So this term was there, which are limited to this extent, that now the service provider and the seller, they also have to be aware of what they are selling, what they are advertising, what they are representing to the customers, to the consumers. So the consumer is now given the advantage over the sellers or the service providers. It is important for the consumer-driven business, such as retail and e-commerce, to be mindful of the changes in the legal landscape and have robust policies dealing with the consumer redressal in place. The consumer-driven business must also strive to take extra precautions against unfair trade practices and unethical business practices. So now the seller or the service provider must know the changes and the amendments in the new acts, which were not there earlier. For some disputes regarding unfair trade practice or the advertisement, earlier we used to go to the civil court for sometimes for the injunction, sometimes for declaration. But now we have the provisions in the Consumer Protection Act itself. So there is a case of in 2020, after the amendment, this is Horlicks versus Zydus Wellness Products, wherein the Horlicks has advertised that it is better than Complan. So this was turned down, that advertisement was turned down by the Delhi High Court. So this is one example that even if it is regarding an advertisement which was detrimental to the consumer, that can be struck off or the bring down by the court. So now the definition under the new act, the definition of consumer has also been changed. A lot of definitions in the act has also been changed, but now the main term, because a lot of people get confused as to whether we are the consumer under the Consumer Protection Act, whether we can file the case. The first thing we need to establish or analyze before filing a case is whether I am the consumer or not. Suppose I am a patient of the hospital and I want to file a case against a hospital. Suppose I want to file a case against the real estate agent for not giving me possession of my property. So I need to analyze whether I am the consumer in the Consumer Protection Act or not. So as per section 2(7) of the act, whoever buys any goods or hires or avails any service. Includes all online transactions conducted through electronic means or direct selling or tele-shopping or multi-level marketing. So that red highlights is the important thing that has been amended in the new act, because earlier the online transactions was not there, or the e-commerce was not there, electronic means was not there. So these have been newly introduced, so that our e-commerce sites, e-commerce business organizations, they should also know all the rules of this act. Now, what is the salient features of the Act 2019? If I have to say, I can say the whole act actually has been changed to some extent. Though there are only a few sections which have been amended, but it is structured the whole section, so a whole act. So under this act, what has happened? The basic features, the salient features, it has a provision of establishment of Central Consumer Protection Authority. So while going through the powers of the authorities, the role of the authority, I came to know that this authority can be a king of the consumer. Like, it is also a consumer. It will act as a consumer. It can file a case against any uneven things done by the organizations. So it is also a consumer. It is the king or the father of all the consumers. So it has a lot of powers, jurisdiction within itself to deal with any issues related to any unfair trade practices or advertisement or any uneven practices done by the sellers or the service provider. So the next thing is product liability option. Earlier, we did not have a provision for product liability. So now what is product liability? Product liability, I am again coming into the definition. Now I'll just briefly summarize the features. Enhancement of pecuniary jurisdiction. As I said earlier, it was 20 lakhs, starts from up to 20 lakhs in the district consumer forum. Now the consumer up to 1 crore can go to the district consumer forum. Up to 10 crore to the state commission. Above 10 crore, they can approach the national commission. A complaint can be filed where the consumer is located. So earlier it was where the other party, the opposite party resides or work for gain, or the cause of action arose. So the new act bring a new rule, a provision that complainant can file a case where the complainant resides or works for gain. So this is an advantage, a very great advantage for all the consumers, because they don't have to move around now with their claim to file within the jurisdiction. Suppose I have purchased a product from Mumbai, and I have come back to Delhi, and I got to know that there is a defect in my product and they have misled me. So initially I had to, under the earlier act, I had to go to Mumbai and file the case, or but now under this present act, I can file it here in Delhi. So this is a very initial and impartial part of this act. So e-filing of the complaints. This is also the rules are yet to be framed, but we can file it through online as well. Establishment of the mediation center. So the provision of mediation was earlier also was there. Suppose I file a claim, the other party comes and other party says that we can pay to some extent, then the court used to send it for the mediation, but there was no proper and formed establishment for the mediation center. But now all the district forum, district commission, state commission and national commission would have the mediation center within their jurisdiction. So introduce filing by video conferencing. This also will take some time for the implementation. The imposition of higher penalties. E-commerce included within the ambit of consumer protection. Penalty for adulteration of products and spurious goods. So these are the salient features. Salient features means these are the new things which have been introduced by the new act. So now I think this table would be a little beneficial, or it will be is easier for us to understand what was not there in the old act, what is there in the new act. So as I said, the pecuniary jurisdiction means the amount, the decided amount has been changed. Now it is up to 1 crore in the district forum, up to 10 crore in the state commission, and up to from 10 crore and above to national commission. Second, initially under the earlier act, the MRP was the criteria to decide the pecuniary jurisdiction. So whatever was fixed in the product, the MRP, it was not under consideration whether the discount, it was the actual price or the discounted price. Now the discounted price or actual price would be a consideration. Territorial jurisdiction, as I explained earlier, we had to go and the consumer had to file the case where the opposite party has the office or resides or the cause of action arose. Now we can file where the consumer or the complainant resides or works. Okay. Mediation, there was no provision, proper provision. Yes, I have been to mediation to the consumer forum, but there was no proper provision for the mediation. So now the court can refer the settlement through mediation under section 80. Appeal, the time for appeal has been changed and increased. Now the person, the aggrieved party can file an appeal in the state commission within 45 days. Earlier it was 30 days, the time for the appeal. For the e-commerce sites, again, there was no provision in the earlier act, and now all the provisions will be applicable to the direct seller. Whatever provisions were applicable to the direct seller has been extended to the e-commerce organization sites as well. So another important provision was earlier district consumer forum did not have the power to review its own order, but now the power has been given to the district forum and state commission as well. Then the unfair terms and conditions. There was no provision for unfair trade practice under the old act, but now under section 49 and 59 of the new act gives power to the state commission and the national commission to declare any terms of contract which is unfair to any consumer to be null and void. And the authority's name has also been changed. Earlier it was forum, now it will be considered as commission. Composition of state commission has also been changed. Earlier it was president plus 2 other members, now presidents and 4 other members. So the last portion, the number of the members, I think it would also be very beneficial to the consumers, because I myself as a consumer many times faced this problem that whenever I go to the consumer forum or consumer commission now, we had to face the lack of members, the lack of president, the absence of somebody or the other. The courts are not hearing the matter properly. So now the question, what is unfair trade practice under the act, the new act? So it would include manufacturing or offering spurious goods for sale or adopting deceptive practices for providing service, not issuing proper cash memo or bill for the services rendered and the goods sold, refusing to withdraw, take back, or discontinue defective goods and services and refund the consideration taken there within the time period stipulated in the bill or within 30 days if there is no such provision in the bill. Disclosing personal information of the consumer to any other person not in accordance with the prevailing laws. So these were not there in the earlier act. So in case of any unfair trade practice, we could not move to the consumer forum earlier, but now we can go to the consumer forum for all these practices. Especially we can experience, I think all of the attendees and dignitaries must have faced somewhere or the other this unfair trade practices have been very common, especially during this lockdown and during this online shopping era. So now a very important point that I have already discussed, that the establishment of Central Consumer Protection Authority would be really helpful to the consumers, because it would act as a consumer for all of us. Suppose some company is violating the rules, violating the rights of the consumers, this forum can suo moto, means on its own can take any legal action against, or can initiate any inquiry against that organization, against that particular advertisement, against that particular product. And if some organization or particular product is promoting some wrong product or giving some false representation, it can initiate any inquiry against the said product or the organization. So this I already have discussed, the pecuniary and the jurisdiction, territorial jurisdiction. Mediation, I have already discussed that the mediation cells will be attached to all the consumer commissions now. So it would be the discretion of the president and the members to send any matter to the mediation for the settlement. Product liability. What is product liability? I think the sellers and the service provider must be aware of what is product liability. Torali, I would really like to request if how much time I have, because I have few slides more.
No problem. You can continue, Ms. Bhanita.
Okay. So what is product liability? Section 84 have been introduced as a product liability because earlier we did not have that option that if we purchased some product which was having manufacturing defect or design defects, or if the seller is saying that the product is of the size of 4x4 but it was 4x2, so that is deviation from the manufacturing specifications, and not conforming to express warranty, that means they are not giving any warranty of the products, failing to contain adequate instruction for correct use. Suppose that we can see some clothes having that only machine washed or only hand wash. So if they don't have any adequate instruction for correct use and the product get damaged out of that due to that, then also it would come under the product liability. And the service provided faulty and imperfect or deficient. So these main bullet points are there, which would really amount to the product liability for the seller or the service provider. So earlier we used to go to the consumer forum only in case where there was deficiency in service. There was no product liability, there was no unfair trade practice. We could not have the chance or option to really challenge those deficiencies. We would not say deficiencies, those mistakes or misconduct on the part of the seller or the service provider. But now we have, under these sections, new sections, we have the option of challenging all the bullet points mentioned here. So there is a case law that is Hyundai Motors India Private Limited, Shailendra Bhatnagar. This was a case where compensation was asked by the respondent. This is a appeal, so that's why I'm saying respondent. So it was challenged that his airbags did not open after a major accident, airbags in the car. So he challenged Hyundai Motors because of the manufacturing defects, your airbags did not open. So the state commission's order directing compensation was upheld by the National Commission. So this problem actually I faced in one of my case, wherein my client's BMW car was stopped during a heavy rainfall, but we had to make the insurance party a major party, the main party, and the manufacturer only as a pro forma parties, because I did not have that option to claim for the manufacturing defect that time. So now we can immediately or directly go to the go against the manufacturing defect of some product, and it would be much easier for us to approach consumer forum. Now the e-commerce rules, which is also a very important thing to be aware by the seller or the service provider. So now this is a online era and online purchasing era. So we must aware sellers or the buyers, we must aware of the rules of the e-commerce provisions under this act. So e-commerce entities are required to provide all the information to consumers, for example, return, exchange, refund, payment methods, etc. These platforms will have to acknowledge the receipt of any consumer complaint within 48 hours and redress the complaint within 1 month. Sellers cannot refuse to take back goods or withdraw services or refuse refunds if the goods and services are defective. It prohibits the e-commerce companies from manipulating the price of the goods or the services. So the case law in Dabo versus Karaltech Private Limited, wherein an advertisement, the Honorable High Court called out the principles governing disparagement in the advertisement and held on the basis of law laid down by the Honorable Supreme Court. The guiding principle for us should be the following. An advertisement is commercial speech and is protected by Article 19(1)(a) of the Constitution. An advertisement must not be false, misleading, unfair, and deceptive. Of course, there would be some gray areas, but these need not necessarily be taken as serious representations of fact, but only as glorifying one's product. So an advertisement must not be false, misleading, and unfair or deceptive. Again, there is a case law on e-commerce. Shri Animesh Vedya versus Amazon sellers. Here the issue was that Amazon claimed that we were not the direct seller. We were just the mediator between the client and the customer and the seller. But the court held that even if you have mediated that process, you are liable under the act now. The court rejected the argument and held that the complainant was a consumer with reference to the respondent and held that the order had not been placed with the manufacturer but the e-commerce platform. The safe harbor provision in the IT Act 2000 cannot be relied upon as a defense in such cases. The e-commerce platform is not just an intermediary but is the actual entity with whom the consumer deals with and has no dealing or contact with the manufacturer directly. Compensation was thus directed to be paid by the respondents to the complainant, and thus liability was fastened upon e-commerce platforms, and they were not treated as mere intermediaries in the transaction. So we have to be aware that even if it is mediator between the consumer and the seller, they are liable for all the acts, for all the advertisement, for all the guarantees or warranties they provide for the product of the actual seller. So these are the main rules of the e-commerce, which needs to be kept in mind by all the sellers and the buyers for their rights and liabilities. So another amendment brought by the present act is the power of review. Earlier, it is a judgment. In this case, the new powers of review granted to the state and district forum, which were earlier enjoyed by the national forum alone, were exercised by the state commission to review ex parte orders. This was done by changing the terms forum to commissions. So this is exactly what I was looking for when I was preparing this PPT, that why the change of the name from forums to commission. Because as a layman, everybody would still continue as a forum. Even me as a lawyer, we are in a habit of saying that it's forum. But now it has been turned into a commission because it changed the nature of it changed the power of the forum now, because as it's a commission, it can review its own order, which was not there in the earlier act. This is a case law in which the Supreme Court has decided whether the cases filed earlier to this act will be managed and governed by the new act or the old act. The Supreme Court says that the old judgments those will be considered under the old act itself, not under the new act. So what are the advantages of the new act? Advantage, the one and very important advantage is there is a provision now that the consumer forum must or shall, the word is used as shall, that they have to decide or admit the matter, admit the case within 21 days. If they don't admit or refuse the case, reject the case within 21 days, then it will be considered as deemed admission. Next is empowerment of Consumer Commission to enforce their own orders. Then appeals only in question of law after second stage. Ease of approaching Consumer Commission, filing from place of residence, e-filing, video conferencing for hearing. These all are the advantages of the new act. What are the drawbacks of the new act? The new act did not say anything about the setup, infrastructure, and staff of the commissions. So we do not get sit there if we go and there is a heavy board in the case. There are a few forums where we do not have the space of standing even. So they have really very bad setup and infrastructure, unbecoming of some commissions. So adding the cases means they have increased the jurisdiction. That means they will be getting a lot of cases now. I think 50 times more than the earlier act, but they do not have the infrastructure and setup for handling. So it has to be taken care of. So after the new act, the small complaints, suppose I am a counsel for DLSL, the Delhi Legal Aid Service Authority. So I have filed one case because I have to file because if the complaint comes. So I have filed one case even for 2,000 for one client of DLSA. So I think increasing the limit up to 1 crore will somehow gives lesser importance to those cases filed for few thousands or few lakhs of rupees. So as per the new consumer forum, the district commission has to decide which case will go to the mediation. This will again give a power to the court whether to send the case for mediation or not. This liability or this power has not given to the party. Only the commission can decide whether the matter will go to the mediation or not. So I think there are a lot of rules, regulations. These are the new rules and regulations which have been newly implemented again under the new act. Rules for e-commerce, rules for appointments, rule for salary allowances, rule for mediation, rule for state commission and district commissions, state commission and national commissions rules. So these are the new rules which have been acted upon now. And the appellate process also I have already explained. The appellate process is district forum, then district commission, state commission and national commission. Only change made under the new act is the period of filing the appeal has been increased from 30 days to 45 days now. So I would like to end my PPT with this. Thank you so much. And Torali?
Yes.
I'm audible.
Yes, you are audible, and we would like to thank Ms. Bhanita Patwari for such a wonderful presentation. It was very much comprehensive and it was a detailed presentation on the revised guidelines of Consumer Protection Act. I'm sure the attendees will be benefited with this information. Thank you once again, Ms. Bhanita Patwari. Now we have,
thank you so much.
Thank you once again. Now we have Madam Leena Das. She got disconnected in between, so she has joined us. So I would like to request Madam Leena Das to kindly address, please. Thank
you. I got disconnected. So, as I have already told you that the State Commission is now functioning with all 5 members, with all 5 positions. That is the president and 4 members. So the State Commission will be functioning smoothly now. the state commission will be functioning smoothly now. And the district commissions also, they have all the precedents in place. Only 13 members are yet to be appointed, for which selection process is undergoing, and we are going to have the selection tomorrow. So I'm busy with that program also. And the mediation cells also, we have notified, we are in the process of notifying the mediation cell for state commission and the district commissions. The Confonet project is also running. The internet connectivity is there in all the district commissions. And the e-Dakhil system, the e-Dakhil, which is ready to be launched through by NIC. NIC has already told us that it is ready for launching, and where the complaints can be filed online in the district commissions and the state commissions. And regarding the direct selling rules, we are in the process of making the rules. Only all the departments have given their views. Only one department still have not given their views, and we are going to get their views soon, and we will make the rules. And in the near future, we are trying to do the consumer activities as much as possible in all the districts, so that consumers become aware of their rights, and they will come to the commissions for guarding their rights. And as there are very few cases in the district commission, so we are trying to increase the consumer activities also. As regards to infrastructure, we have called for information from all the districts, especially from the deputy commissioners, regarding availability of land, so that we can send proposals to the government of India for setting up buildings with better facilities. And these are all the activities we are taking under consumer affairs. And as per and we have to comply with the Supreme Court's orders also. The Supreme Court has also told us to fill up all the vacancies, and also regarding infrastructure and staff, we are trying as much as possible to fill up all the vacancies of the staffs also. Thank you.
We would like to thank Madam Leena Das for this information. These are really impactful, and also I would like to thank you for updating us on various activities that has been initiated by Government of Assam to protect the consumer rights. Thank you once again, Madam. Now I'd like to request, yes, we have Professor Bijan Kumar Mishra, sir, who has joined just now. He had to join a little bit lately because of some urgency from his point of view. So we would like to have Professor Bijan Kumar Mishra to kindly address, please.
Actually, I also want to tell you, hello.
Yes, madam.
Actually, I have the selection process tomorrow, no? So if you allow, can I take the leave?
Okay, ma'am. Surely, we would like to thank you, madam, for managing your valuable time for us. We would also like to thank Devasity Dr. Sir and Vishwaranjan Samal Sir also for to the entire Department of Food, Civil Supplies and Consumer Affairs Department, Government of Assam. Thank you, madam. Thank you so much.
Thank you.
Now, I'd like to request Professor Bijan Kumar Mishra. Sir, he's the international consumer policy expert, and he's the advisor to the Government of Orissa Consumer Protection, and he's the honorary professor of the National Law University Orissa. So we are very much delighted to have Bijan Kumar Mishra sir with us, and he had been supporting us continuously. So once again, he has joined us. We are very much delighted to have you, sir. So I'd like to request Professor Bijan Kumar Mishra to kindly address, please.
Thank you very much, Tarini, for again giving me this opportunity. Firstly, I would like to sincerely apologize for joining in late. I had certain engagements which came up, where I couldn't say no, but I tried to manage in a manner that I could come and join you all towards the end. And as per my promise, I have been able to make it. I'm happy about it. And I feel very delighted to be here. Thanks all the time for organizing such awareness programs in the state of Northeast, which is, I feel very proud and happy. And not only Northeast, you've done it in Eastern India, like Orissa, you've done a program. And I'm sure you will continue this campaign with Sandeep and other partners who are supporting you in taking this forward, especially IDSA, which is a very active membership-based organization of Indian direct sellers and all known people. I would like to again take this opportunity, and as you are doing it in Assam, which is a very state which has a big legacy and a lot of expectations from the citizens of the country from a state like Assam, because it was always seen as a leader in the Northeast region. And whatever Assam will set up would definitely become the kind of a golden standard for all the states in the country. And firstly, I want to say, and I'm very sorry that I couldn't hear the opening remarks and the inaugural session and what the officials had to say. I couldn't, I was not privy to that, and I do not know what they conveyed. But what I heard the moment I came in is that the filling of vacancies in the courts and issues like that. You see, my question is very simple. When the Consumer Protection Act came forward in 1986, the whole objective was how to empower the citizens who is a consumer. And consumer has been well defined. What is a consumer? Who once you pay the money or you promise to pay your money, then you become a consumer. And once you are a consumer and you have paid your hard-earned money to access a product or a service, then you have certain rights. And those rights got enshrined in that law, which of course every law is derived from the constitution, of our country. But unfortunately, in our constitution, there was no mention of consumer at that point of time. We had mention of citizens at that point of time. And of course, consumers are also citizens. So having said that, and when I was very fortunate again to be party to that whole exercise of making that law, the Consumer Protection Act of 1986, in 1986, because I joined the movement in 83, and that was one of our major victories at a very short time when we got the law in 86. Because the consumer got a legal face after 86. And there was a very robust, complaint redressal mechanism put in place, which was quasi-judiciary kind of an activity or a kind of a network which was built around the country. And the central government agreed that we will support in setting up this infrastructure, along with the state governments, of course. And the state governments were made party to it. And one after another, the states started implementing the law, which started from 1987. And Bihar, I still remember, because I used to live in Jamshedpur, and Bihar was my state at that point of time. It was not divided between Jharkhand and Bihar. So Bihar was the first state to implement the law. And I was very happy that I was party to that too, because I could convince the chief minister that it's a very important law in the interest of the citizens. And the first state commission started functioning from Patna, from the veranda of a retired Justice R.N. Thakur, who further went to Assam in terms of a commission, who got moved to Assam as a retired judge on a commission. So it started from the veranda. So what I'm trying to convey is, if the consumer movement has to flourish in the country, then it has to be a mission mode activity. It was not devised as a kind of a tool which was like any civil suit or any civil law or a regular judicial system. It was perceived and conceived in a manner that it would be in a manner which a common man can access prompt redressal. That was for the first time, there was a timeline given, 45 days. The decision has to be made. But is it happening? It's not happening. There are a number of challenges. I am not saying that, somebody is right or wrong. I'm not saying somebody is efficient or inefficient. I am saying that we all need to work together to move forward, like ICC is trying to do this activity with IDSA. How we can engage with the government, how we can help the government to make it happen the way we need it. Today, because of technology, the new law, the Consumer Protection Act, is now absolutely reformed and it's in a different shape now, which started existing from 2019, and in 2020 we have the rules. Now we have the Central Consumer Protection Authority. Apart from Central Consumer Protection Council, state councils, district councils, we have all these in place. But how many of it are functioning? And the Supreme Court has gone ahead to say recently, which was a very, very strong statement made by the Supreme Court, that if you have a law and if it is not functional efficiently, then withdraw that law. There is no point having a law, which was very rightly pointed out. And the Supreme Court took suo moto the burden of looking at why the state governments are not working in the manner they should be working in the implementation of the Consumer Protection Act 2019. What is the delay? Why should there be a delay in selections of people? Because you know their term, that somebody's term is ending at such and such month in such and such year. Much 6 months before that, you should start the process so that by the time the person retires, the next person is standing there to take over. No, that is not a rocket science. Come on. It can be done in a manner which we all can agree to do together. But the government, in order to make it happen, there has to be a strong leadership. That leadership has to come from a mission mode, commitment, high degree of commitment. Like for example, direct selling industry, because they're concerned with this activity today. What I want to say, that it took us so much of effort to bring direct selling into the format of a legal format of trade. Only the people who were beneficiaries from direct selling knew it, but nobody was trying to understand, the policymakers, that they need to be protected. India has huge opportunity in direct selling business, which will not only generate employment, but will promote quality. And what I am trying to convey is that you would lose an opportunity if you don't work on time. And you could see other countries, how they have benefited from direct selling, and India has lost out. But it's never too late. We have been able to bring now direct selling into the ambit of the law and give protection to the people who are into the direct selling business, including the consumers, so that they are not looked at as Ponzi companies, or they are not looked at as companies who are defrauding the consumer. They have a code of ethics. IDSA, I know, has a strong code of ethics in terms of their conduct of business. They have a code implementer, a person who you can go and complain if you find that any of the members of IDSA are violating the code. And there are a number of mechanisms. So what I would like to tell Indian Chamber of Commerce and the state government like Assam, that let's develop a good partnership, number one. Number two, let's understand how we can make the processes and systems as per global standards. Let's understand how we can ensure that the lowest person in the rung, the person who are on the bottom of the pyramid, who spend 50 rupees, 100 rupees, 200 rupees to access a product or a service, how can that person be assured quality? I want to tell all the viewers today that the month of November is observed as the World Quality Month. And this year the theme is sustainability, improving product, people, and planet. So what we need to understand is when we are talking about direct selling, when we are talking about the direct sellers, we are also talking about good quality products made accessible to the consumers at the most affordable price. And not only that, the best format of that whole business of direct selling is that it also generates employment, self-employment, self-esteem. And as you all know, I'm sure somebody would have, shared with you, Sandeep would have shared with you, or somebody would have shared with you, the kind of engagement with women, especially in direct selling in India, and the opportunities which are there. So I appeal to the government of Assam, let's not miss this opportunity. Let's convert it into a real good business model, a real good opening and a solution to the youths, especially, who are seeking employment, who want a good livelihood, whose per capita income needs to be increased. Let's work together to do that in the interest of the consumers. And I'm sure Assam government would be listening into this program and will engage with all the stakeholders to ensure that there is no compromise on quality and all the consumers are given the right share in terms of their rights legally without getting into the format of litigation and getting into a dispute. So thank you very much, Talini, for giving me this opportunity, and I will be happy to take questions if time permits. And thanks a lot once again to ICC and all the organizers for giving me this opportunity and inviting me. Oh, Chetan is also there. So I'm sure if Chetan has spoken, he would have made everybody walk through the activities of IDSA and how IDSA has been performing in terms of the great work which they are doing. So wonderful to see all of you and happy to be again part of this conversation. Keep inviting me. I'll always be there. Thank you very much.
I would like to thank Professor Vijan Kumar Mishra for this insightful presentation, and it was really very, very informative. And sir has rightly said that the implementation is actually very, very important. And sir has also rightly highlighted the importance of the role of state government in ensuring the rights of consumer. We are very, very grateful to sir for highlighting all these crucial issues. So thank you once again, Professor Vijan Kumar Mishra, sir. Thank you once again. Now I'd like to request Mr. Chetan Bharadwaj, the General Manager of Indian Direct Selling Association, to kindly address, please. Thank you.
Thank you so much, Tarali, and good afternoon, Bijon sir.
Good afternoon.
Unless I hear what you have to say, I cannot say anything because from whatever you present, we make our own addresses actually. And I think Tarali, there's nothing much left for me to actually say. Bhanita ji has given a very exhaustive presentation on what all different aspects of the new Consumer Protection Act are. And of course, my warm regards to Leena Das ma'am from representing the Department of Food and Civil Supplies, Government of Assam. I think ma'am is not here now. But yes, ma'am, we would like to assure you the full cooperation from behalf of Indian direct selling industry. Assam, as Sandeep said in the beginning, holds a very special place for direct selling industry in India. Assam is currently ranked at number 9 in overall, if we rank, different states in India in terms of sales. So in 2019-20, Assam generated overall gross direct selling sales of over 770 crores, which represents roughly 5% of the overall Indian sales. And close to 2 lakh people are working in the industry from Assam as active direct sellers. So yes, Assam may be representing 5% share, but if you divide or if you arrive at the per capita contribution, Assam is probably right there in the top 3 states. And not just Assam, in fact, the whole northeast region is actually driving the growth of direct selling industry forward. And segments like nutraceuticals, cosmetics are doing wonderfully well. In fact, what we have seen is the many companies are in fact launching their products first in the northeastern market, and then they move out to other markets like cities in north or cities in southern or western India. So it's very commendable, and people of northeast India have welcomed the direct selling industry with open arms, and they are becoming a part of it. So the future is bright. Coming on to the topic of the day, Consumer Protection Act 2019. As I mentioned, Vanitaji has already covered in sufficient details what exactly is there in the new act, which was not there in the previous act. In this series of webinars, now I have been making this submission again and again that it's a welcome step. There is absolutely no denying this fact. India was one of the first few countries to come up with a dedicated law for protecting consumers in terms of the Consumer Protection Act 1986. Of course, Bejon sir is here, and he was the key driver behind its notification as well. And of course, the 2019 Act also. As a layman, not as a student of law, what if I compare at the macro level these two acts, primarily both of them deals with the 6 rights of consumers, that these acts aims to protect. As a layman, as I said, at the macro level, the difference between the two acts lies in one of these rights. Now, the 6th right deals with the right to consumer education, which was enshrined in the 1986 Act. Now, this right to education, consumer education, has been changed to right to consumer awareness in the 2019 Act. Now, most probably, many people will probably feel there's not much of a difference between education and awareness. But yes, if you try to get into depth of it, education can simply be defined as a process of imparting fundamental knowledge. Awareness is something which is achieved through education, training, and experiences. So clearly, the objective behind the new act is much wider one. The objective is not only to make a consumer educated about his right, but to make a consumer aware about his rights, how he can exercise his rights in the most efficient manner. So, in my opinion, the 2019 Act, the goal, if we talk about, is to change culture sensitivity to this whole topic of consumer awareness and consumer rights, consumerism in India. Moving on, there are a couple of good things. Central Consumer Protection Authority, which has been enshrined in Chapter 3 of the Act. It's a very noble initiative. The authority is going to act on all issues concerning promotion, protection, enforcement of consumer rights, wherever consumers as a class is involved. Now, CCPA, the Central Authority, has been given an investigation wing as well. Investigations shall be conducted by an officer not less the rank of district collector upon receiving orders from CCPA or commissioner of any regional office of CCPA. So this is another wonderful thing. CCPA can take suo motu cognizance if they see they don't really have to wait for a complaint to come. If they feel that something is apparently going wrong, they can take suo motu cognizance of it. One issue which I feel needs clarity is as per the provisions given for CCPA, clearly CCPA is a very important body. In fact, if you start ranking it in the hierarchy wise, the Honorable Supreme Court is right there at the top, followed by National Commission, and then of course the CCPA. Act on one place says that CCPA can intervene in proceedings of the district, state, as well as National Commission. So clearly, the objective behind putting such a clause is to give more powers to CCA. On the other hand, the Act also says that an appeal against CCPA can be filed in National Commission. So in my opinion, there is an ambiguity here. On one hand, CCPA can intervene in the proceedings of National Commission, and on the other hand, National Commission, an appeal against CCPA can be filed in National Commission. So I'm really not able to understand which of these authorities, CCPA or National Commission, is probably higher than the other. So this is a little ambiguity which I feel is there. Moving on to the next good thing, Consumer Disputes Redressal Commission. Vanita ji made a very exhaustive presentation on this important issues as well. In my personal opinion, these dispute redressal commissions, if I try to rank or if I try to point out one single thing that this Act promises, is this Consumer Dispute Redressal Commissions. This is the single biggest positive change that this new Act has actually brought in. First, and of course, the complaint can be lodged at any district Even earlier you don't have to probably approach the place from where the product or service was purchased or availed. Now you can file a complaint sitting at your home district also. The company will come and fight the case. It's a big relief to the consumer. Second, the jurisdiction of district forums. Now they have increased to 1 crore from 20 lakh, which I feel is kind of a sufficient amount now. 99% of the issues will now be getting resolved at the district level itself, and this will certainly decrease the case load on state commissions and of course going forward the national commissions. Third, earlier only the national commissions were given the power to review their orders. Now even the district commission and the state commissions have also been given this power. So this will certainly cut down the litigation time as well going forward. Bharita ji discussed this in detail during her submission. Mediation is another important aspect of it actually, which the new act has proposed. So introduction of mediation is one of the most important steps in my opinion, and this will go a long way in settling consumer dispute. There are, I think if you check online, there are plenty of case studies from around the world that shows how mediation has actually helped not only in decreasing the case load on the judicial system, but has actually provided a mechanism for speedy resolution. Now mediation, what happens is considered to be a fair and impartial way of settling a dispute. Now, consumer dispute, what happens is that an individual consumer is probably up against a big corporate or a big entity. So there's a need to instill confidence in the consumer that as an individual you are not alone. There is a system protecting your rights and we are there to help you out. So mediation ensures building of that confidence. And of course, the elaborate mediation system that has been incorporated in the Act will help in clearing the number of cases handled by all the commissions, the district commission, state commission, national commission. So this is also another important development in the new Act. Now, product liability clause. Another good thing about the new Act is that there are clear distinctions that have now been made in what circumstances the product manufacturer is at fault and in what circumstances the product seller is at fault. Now, earlier, a lot of litigation time used to get wasted in determining who actually is the party responsible for the infringement of the consumer right. Now, there are clearly well laid out situations given in the Act. So, a consumer straight away knows in what circumstances I have to hold product seller liable or in what circumstances I have to hold the product manufacturer liable. So, again, this will save a lot of time for everyone. Unfair contracts is another important thing that has been added in the new Act. Now, previous Act, if you talk about the 1986 Act, now it had provisions regarding unfair trade practices. However, unfair contracts was not mentioned anywhere. Now, new Act clearly defines that an unfair contract is something where the terms of contract can cause significant change in the consumer rights, the 6 rights that have been given to a consumer. Further, the state commissions and the national commissions have been given the power to declare any term of a contract which they believe is unfair to a consumer as null and void. So this is a great power that has now come to state commissions and national commissions, and I hope this will go a long way in ensuring that the rights of consumers are protected in the country. Restrictive trade practices. Now this is another area where I think a fundamental difference has been brought in the definition itself compared to the previous Act. Now earlier, if you talk about the 1986 Act, restrictive trade practice was defined as a trade practice which requires a consumer to buy any good as a condition precedent for buying, hiring or availing of other goods and services. Now clearly, restrictive trade practice is not limited to this alone. Okay, yes, this is also one of the aspects that you are compelling a consumer to first buy another product if he wants to buy this product. But this is not something which the restrictive trade practice is all about. So the new Act has enhanced the horizon of the definition, and it has now defined a restrictive trade practice as which tends to bring about manipulation of price or its condition of delivery or to affect flow of supplies in the market relating to goods or services in such a manner as to impose on the consumers unjustified costs or restrictions. So clearly the definition has widened to a broader horizon now, and consumer rights are definitely going to get protected because of this widened horizon of the restricted trade practice definition. Moving on, since I'm representing direct selling industry on this important platform, so again, good things about the new Act is that CPA, the Consumer Protection Act 2019, is the first Act which has explicitly mentioned and defined what direct selling is. Now, prior to this, central model direct selling guidelines were there, which were notified in the year 2016. But yes, CPA 2019 remains the first and the only act till now which clearly enshrines the definition of direct selling business model in the purview of the main act itself. Now, this is again carried forward to, I think, the definition of consumer also, which I think, if my memory serves me right, mentioned in clause 2.7 or clause 2.8. The consumer, where it has been defined that consumer means something who buys any goods or hires or avail any services. There again, explicitly it has been mentioned that buying goods or hiring services include direct selling as well as multi-level marketing. So clearly, the new act has opened the doors for a bright future for direct selling, and the ministry is now working very actively on coming up with the central direct selling rules under the purview of Consumer Protection Act 2019, which will certainly pave a way for the industry to grow in the near future. Now, again, since I'm representing direct selling industry here, so it would not be wrong for me to say that direct selling industry is in fact one of the few industries that are actually, since their inception, working for the promotion and protection of those 6 fundamental rights of a consumer. If you look at all of them individually, now, for example, first right of the consumer which has been given in the act is right to be protected against the marketing of goods, services which are hazardous to life and property. Now, what happens in direct selling? Products are sold by individual direct sellers who are in fact consumers of those products themselves. So clearly there is no issue of marketing hazardous goods to other people, because our direct sellers are our sellers who are actually consuming those products themselves. Second right, if you talk about the right to be informed about the quality, quantity, potency, purity of the product, again, one of the primary reasons why a consumer orders product from a direct selling company is because it trusts the product. It trusts the person who is selling that product to him. Of course, the direct seller is a known person to such a consumer, and he takes a personal guarantee of the quality and quantity of the product because he has already consumed that product for a sufficient period of time. Third reason, the right to be assured wherever possible access to variety of goods. Again, we are able to at competitive prices, I think, is the exact term included in the third right of the consumer. Direct selling was created as a business model to offer products to consumer at a competitive rate, because we eliminate all the typical retail supply chain intermediaries from between, and that's why we are able to offer world-class quality products to our consumer at competitive prices. The right to be heard and to be assured that consumer interests will receive due consideration, that's the fourth right. Again, direct selling business is directly proportional to the satisfaction of our direct sellers and our consumers. So even before such things come to act, all direct selling companies by default have an excellent redressal system, grievance system in place, wherein all the queries or complaints of a consumer or direct seller are very well addressed. The right to seek redressal, the fifth right, again I've already discussed. Right to consumer awareness, the final right which has been mentioned in the Consumer Protection Act. So again, direct selling companies invest a good amount of their resources in making the consumer aware about the benefits of the product. See, why direct selling as an industry started? Because there were some products which we feel the benefits of which can be explained to a consumer only through personal sessions containing training sessions, or maybe after having a personal one-on-one interaction with him. So during this process, or when this process is being executed, we make consumer aware that this product, there are alternatives available in the market, but why we are offering you this product through direct selling channel is because of the certain benefits that you are getting from here. It could be the competitive price, it could be the fast delivery, it could be the facility to return the product in 30 days if you're not satisfied it could be any other advantages, numerous advantages that direct selling entities offer to their consumers. So we are making consumer aware, because consumer awareness is actually what is driving the sales of the direct selling entities. So with this, I would like to conclude my submission here, and I hope I've been able to make some interesting points relating to the Consumer Protection Act and of course how the direct selling industry operates in its purview. And in case there are any questions, I would be happy to answer. Back to you, Tarali.
Yes, we would like to thank Mr. Chetan Bharadwaj. It was really a very, very insightful presentation. And you have clearly explained the various, like the differences of the old act and the new act and how the consumers can actually be benefited with the new act. So it was really a very, very informative presentation from your end. We would like to thank you for that. So with this, we are proceeding towards the end of today's webinar. But before that, we have the interactive session that is for question and answer. And for that, I'd like to request our IT team to kindly help our delegates.
Tarani, just one.
So that,
Yeah, with your permission, sorry, I forgot to make one. Just wanted to share an information with all your audience. So, as I mentioned,
Sure.
Northeast is one of the key markets that is driving the growth of direct selling industry in India. And in order to celebrate this contribution of Northeast region in the growth of direct selling industry in India, IDSA is coming up for the first time a Northeast Direct Selling Expo in Guwahati on December 2nd. And we would like everyone to come and be a part of the event, witness the companies who are putting their stalls there, and it would be a fun and informative day. December 2nd is the day from 10 a.m. till 6 p.m. Thank you so much.
thank you so much for sharing the information. I'm sure all our
What's the
delegates
venue,
will be
Mr.
visiting.
The venue would be Netfee Convention Center on GS Road, opposite to Assam Secretariat.
Okay. Next to our office too.
Yes.
Okay, wonderful.
Yes, thank you so much for sharing the information. Now we would like to go ahead for the question and answer session. And for that, I would like to request our IT team to kindly help our delegates so that they can unmute themselves and ask their question. So can we have the questions from our delegates, please? I would like to request our delegates, the attendees, to kindly unmute yourself if you have any query, if you have any question to ask.
If you allow me, I just wanted to bring a clarity in what Chetan mentioned.
Surely, sir.
So Chetan, you wanted a clarity in terms of the role of CCPA vis-a-vis the National Commission.
Yes, sir, because I feel there's a little bit of contradiction in the provisions. Now, CCPA.
So
Yeah.
let me tell you the rationale.
Yes, sir.
CCPA is given a legal authority to intervene on behalf of the consumers or intervene on behalf of any person or any body. Like supposing tomorrow you all approach CCPA, then they can also intervene on your behalf, before the National Commission, State Commission and things like that. That is number
All
one.
right, sir.
Number two, in terms of reporting, National Commission reports directly to the Supreme Court.
Yes.
So if supposing, CCPA wants to say certain things to National Commission, they cannot say without the permission of the Supreme Court. They have to go via the Supreme Court. But they can intervene. So there is the word intervention. So
Right.
CCPA has been given the powers to intervene, but not in terms of administrative powers.
Right, sir.
They can always bring it in the notice of the Supreme Court, but the Supreme Court is the only authority which has the authority to oversee the functioning of the National Commission. I hope I was clear.
Yes, sir.
Thank you, sir. Thank you so much. I'd like to confirm from the delegates, and is there any question? I hope there is no question, and I'm sure the inputs from our speakers were so elaborative and so informative that every doubt got cleared. So really, we had a wonderful session today. So with this, we would like to conclude the presentation. And before concluding, I would like to thank all the speakers of today's webinar. That is in spite of having their busy schedule, they had to manage their time to attend us and provided us various informations. So I'd like to thank Ms. Leena Das, the Additional Secretary of Food, Civil Supplies and Consumer Affairs Department, Government of Assam. She had to attend the webinar at the last moment by managing her busy schedule. So it was very much informative information like shared from her like her side. So it was really nice. So I'd like to thank Leena Das madam. I would like to thank Professor Bijan Kumar Mishra sir. Sir had always been supporting us, like in every webinar that we had been conducting. So we are really thankful to you, sir. And the presentation you shared was very much informative to all of us. So we'd like to thank you, Professor Bijan Kumar Mishra. Would like to thank Ms. Bhanita Patwari, who has joined us from Delhi. So we are very much thankful to Ms. Bhanita Patwari. In spite of having your busy schedule, you could manage your time for us. And your presentation was really very much informative. It was a comprehensive presentation wherein the participants had been benefited by knowing the various aspects of Consumer Protection Act. Thank you once again, Ms. Bhanita Patwari. Would like to thank Mr. Chetan Bharadwaj, the General Manager of Indian Direct Selling Association. Thank you so much, Mr. Chetan Bharadwaj. You had always been associated with us and you had been supporting us. So thank you once again, Mr. Chetan Bharadwaj. I'd like to thank Mr. Sandeep Mukherjee for supporting us, as well as MP India Enterprises had been supporting us a lot. So it had been like we have already conducted 4 webinars till now for the states of Eastern and Northeast India with your support. So it had been a continuous support from your end. So would like to thank you, Sandeep Mukherjee, once again for your continuous support. Madam Nidhi Khare could not join us today because of some urgency at the last moment. Although she could not join, she had always been supporting us. For that, I would like to thank Madam Nidhi Khare, as well as I would also like to thank Mr. Biswaranjan Samal, the Principal Secretary of Food Civil Supplies and Consumer Affairs Department, and Mr. Debojyoti Datta, the Secretary of Food Civil Supplies and Consumer Affairs Department of Government of Assam. They had been coordinating with us and they had supported us a lot. So with this, I would like to thank all our esteemed speakers of today's webinar, as well as the personals who had supported us to conduct this webinar. I would also like to thank all our delegates for joining the webinar, for taking the information, and for making the webinar a successful one. Thank you, all the delegates present over here. I would also like to thank, special thanks, in fact, to MV India Enterprises Private Limited for taking this initiative and joining with
I think she got disconnected.
I think there's a technical glitch.
Yes.
So maybe
Yeah. Anyway, I think we can
take over and conclude it.
Yeah. So I would like to thank everyone for joining this important discussion, and hope we'll have some more in the near future. Thank you all very much. Thank you.
Thanks a lot. Thanks a lot. Banita, I missed
Thank
your
you.
presentation.
Thank
Banita,
you so
I
much.
missed your presentation. I'll be very happy if Tarali could
I
share
got
her
this.
presentation with me on
Sure.
the email. That will be very nice of you.
Surely, sir, surely.
It'll be
Thank you
nice
so
to
much.
Thank
go
you.
through it. Yeah.
Very nice to see you all virtually, at least.
No, we will meet soon. We will meet soon.
So
And-
we'll meet soon.
and
Thank you so much.
keep doing this good work, and do share your presentation with me.
Surely, I'll do so. Thank you so much.
Thank you.
Thank you all.
Thank you, everyone. I got disconnected in